The Copyright Act is a very old piece of legislation, and it was required, became a necessity that we amend that act in order to take into account the technological advancements that have taken place worldwide. But another factor, which is partly, I think, the genesis of a lot of the problems, is that there were some very real, and still are some very real challenges in the industry, the music industry in particular. As a result of lots of indabas, white papers, green papers, strategy documents, et cetera, and government intervention, a lot of these challenges were identified. So bad contracts, people dying poor, people being exploited, et cetera. And you see that theme that runs through the current drafting of the Copyright Amendment Bill. Now, the intention to draft is correct. The challenge with the bill is that how it manifests itself, what people are hoping to get out of it in terms of protection, ultimate protection for creators, is not what is coming out. Because the copyright system in itself, the bill, is a careful balancing act between protecting creators for what they've created and also allowing users access to that. But in that access, they should be able to compensate the people who created the works. So those challenges come up in how the act has been drafted. For instance, there's certain exclusions that have been created or that have been put into the act, which would be devastating for creators. But not only that, the drafting in of itself is not in compliance with international treaties. South Africa is a signatory to international treaties. We are signatory to the Berne Convention, TRIPS, trade-related aspects of intellectual property, where they stipulate that as a signatory, when you're amending your legislation, you're required to have a 3-step test to ensure that A, you don't interfere with the normal exploitation of the works by the creator, and you don't prejudice their rights. This bill fails to meet that standard. There are provisions around fair use, which is the access that you're talking about, where it would allow users basically free use to creators' works without taking out a license and having those creators compensated. Now, as a principle, fair use is not necessarily bad as a principle, but it works in certain legislations. That fair use principle is transplanted from US legislation. And not only is it transplanted, we've gone a step further and expanded on how much users can use works. And not only that, because of that transplantation, we've not taken into account the fact that that piece of legislation also has punitive statutory measures in it so that it can counterbalance any sort of abuse of use of works. So we've taken that without taking into account that our context is different. We've expanded and we've not put in a countermeasure in the bill itself to deal with gross infringement of copyright. And another factor is that provision places the onus on the creator, really, to prove infringement of copyright. And in order to prove infringement of copyright, you need to go to court. We're not a very litigious society. The states, they're quite litigious, so they're used to going to court for every little thing. They've also got well-established jurisprudence dealing with copyright issues. We don't necessarily have that. But the sheer cost of trying to go to court for a normal South African creative, it's impossible. So you find that the people who are suffering the most are poor, in particular, black creatives who won't be able to take, in particular, big corporations to court to prove copyright infringement. Because, I mean, just to speak to a lawyer for an hour, in most instances, you're looking at about 1,000 rand or more. Right. And I'm just thinking about Trevor Manuel now in this Peter Moyo fight, where he's like, it's fine, you can take us to court, let him run out of money. Yeah. So that's the type of thinking that you'll be dealing with. So, I mean, those are just some of the provisions that are problematic in the bill of itself.